Okay, I'm going to acknowledge something that I was not aware of before, and I just found this. It's in a historical note, and what it says here is that um, concerning the law regarding magistrate judges, that Public Law 90-578 of October 17th of 1968, 82 Statute 1111A, discusses the authority for United States magistrate judges or United States magistrates. On October 17th of 2017, I submitted a motion to the Supreme Court of Texas regarding a consideration of my understanding that at that time there was an act of securities fraud connected to my efforts to go through the Supreme Court of Texas. And I submitted a motion to withdraw because my understanding is that what was happening that day is they were using my case in an act of securities fraud. That act of securities fraud, as I understood it at the time, was connected to a number of municipal bond issues that were occurring in states. There were three different states of concern, two of which I had lived in formerly, and one of which my sister lived in at the time. And all of these bonds were connected to some sort of housing bond, a large scale housing bond. My direct concern was that this might be in some way connected to something that got set up on me when I was in high school. And I didn't have any understanding of what that meant or why that would be ongoing at the time. But I will say that since October 17th of 2017, I had a need, including the next year, to file a follow up report with the Internal Affairs Division in the state of Texas, specifically the Houston Police Department Internal Affairs Division, with my understanding that there was a major bond issue at that time that had significant implications, including international implications. And not only that, but in the 2 years following that, there were major actions that were taken by political candidates for office, or at least one that at the time was running for president of the United States, and another candidate for office that had formerly run for president of the United States and was involved in an altercation with a sitting member of Congress. That on that specific day, that what I had discussed or what I presented as a motion to withdraw actually got effectuated in some sort of manner that was actually reported on in the media, wherein a woman in either political office or a woman candidate for political office withdrew. She withdrew from an event in which she was involved. But it didn't seem to correlate directly in a manner that I could confirm at the time. What also didn't correlate was why it was that the Supreme Court of Texas never acknowledged receipt of that motion, but acknowledged receipt of other motions. Now, this has been something that's been ongoing to this time. I did not know that October 17th of 1968 was the day that they passed or implemented the law regarding the role of United States magistrates. I contend that is absolutely 100% materially relevant right now. And I also want to say that it is very disappointing because, A, it is potentially impugning on the character of those who are legally serving as magistrates in either federal district courts or in other comparable jurisdictions. B, it is indicative of a pattern of repeatedly engaging in intentionally orchestrated acts of securities fraud based upon a refusal for the Supreme Court of Texas to engage a good faith effort to respond to my concern that there was concurrent activity going on in regards to my case to go through the Supreme Court of Texas. This goes all the way back to 2017. But at the same time, one of the manners of which this is concerning is regarding specifically law associated with magistrate judges. In the rules of appellate procedure, there is a law that says abrogated. And that's so ironically, it was abrogated on April 24th of 1998. I'm in Dallas, Texas. What happened on April 24th of 2018? Exactly 20 years later. Exactly 20 years later, there was an incident where a police officer from the Dallas Police Department, actually two police officers from the Dallas Police Department, were responding to an incident that was alleged to be ongoing at a Home Depot and were shot. One of them ended up dying. I contend this was not just a random event. This was a premeditated hit. The officer who died, his name was Santander. Santander Bank at that time was undergoing a proceeding where it was trying to get approval through the Federal Reserve System for a specific kind of package of housing remedies and housing services and housing related provision of services and practices that it had been for at least 2 years attempting to try to get approved through the Federal Reserve System. Now, since Officer Rogelio Santander was killed, they've actually gotten that approved through the Federal Reserve. But nobody in Dallas to this time has taken any of the evidence I had since I had it when I came here in May of 2018 and has engaged in an actual investigation of allegations of securities fraud, including securities fraud connection with pension fraud, including pension fraud that is using police pension systems to launder money in connection with highly illegal activities, including activities that legally constitute acts of domestic terrorism. These two things are not unrelated. They're directly connected. And so now we're at this very specific point where it is evident that somebody is abusing not only my rights to due process, but is in abuse of a number of what are supposed to be legal remedies for addressing acts of fraud, threats of violence, dispossession of property, things that are rights, up to and including actually visiting acts of violence in the form of threats of fatal violence that may actually result in fatal violence. All of these things are unfortunately compromised by virtue of the fact that, again, for now the fourth time and the fourth effort at presenting a legal case in order to achieve my own access to rights to due process, including housing safety, have been compromised by an effort to try to compel me to cooperate with a scheme that now I have another level of cognizance is directly connected to my original allegations of trafficking after and in accordance with kidnapping people in acts of securities fraud. Now, if you want to argue with any number of or any of the charges by the letter of the law, let me just say, and I will just say this, Rule 3.1 that has that dated reference and discusses abrogation in 1998 refers to another rule, right? Rule 3A3, which discusses the role of the magistrate judge. And what it says is, an appeal from a judgment by a magistrate judge in a civil case is taken in the same way as an appeal from any other district court judgment. A problem is, a magistrate judge does not have the same authority that a district judge does. A magistrate judge a judge may also designate a magistrate judge to conduct hearings, including evidentiary hearings, and to submit to a judge of the court proposed findings of fact and recommendations for the disposition. However, in accordance with this, there are standards that the judge is held to, insofar as the judge is only authorized the power to enter a sentence for a petty offense and the power to enter a sentence for a Class A misdemeanor in a case in which the parties have consented. At no point in time was there ever consent to proceed before a magistrate judge. The actual designation of the magistrate judge by default through an automated process is distinct from an actual federal district judge designating the magistrate judge to comply with or participate in certain dispositive or other pretrial matters. To automatically ascribe a magistrate judge by name to produce a effort to obstruct due process via an automated system that merely provides a misrepresentation of the actual charges that are being sought before the court, especially when it continuously engages in a kickback scheme requiring reinsertion through the automation in what has already been orchestrated as material misrepresentation and materially false information about the charges, when in fact it is demonstrated over and over again that the authority for the person who is being put in that position in a manner that does not comply with the law is being compromised by virtue of the fact that it is connected to the very fraud scheme that was itself the subject of the original charges. This is now the fourth time that a misrepresentation of it being appropriate before a magistrate judge has been thrust upon me instead of me being able to receive my access to rights to due process. This has gone on for 4 years. 4 years of me actively, diligently, legally trying to pursue my rights to due process. That is completely unacceptable. By the way, it has already been presented in a formal filing to the specific magistrate judge of concern that due to the nature of the charges, the magistrate judge was not even appropriate in consideration of the charges at hand, specifically and especially in dismissing the charges under false pretenses, i.e., lacks jurisdiction, engaged in bad faith, or other efforts to try to ascribe the case at hand as somehow having to deal with subject matter that was not actually presented as part of the filing or part of the motion, and instead try to associate the charges, including the severity of the charges, with a lesser offense, including a lesser offense that involves a dispute connected to property. Are we talking about disposal of the corpus? We'll see. If you would engage a good faith effort to actually represent the people in performance of your duties as a judicial officer, then the original request for a new trial in consideration of a filing of a writ of habeas corpus would have significantly different implications than it does right now.